Hello, and thank you for listening to this podcast. My name is Karen Killalea. I am a partner and head of the employment team at Maples and Calder, Ireland, the Maples Group's law firm in Dublin. Before I dive into today's subject, just some housekeeping to cover off. If you are listening in from your usual podcast app, you'll find any resource documents that we reference during this podcast and speaker information in the show notes. And if you've clicked on the media player link sent to you via email, you can find this information in the notes section. Please note that this podcast contains a general overview on the topic of retirement ages and some related issues which may be of interest to employers in Ireland. It does not constitute legal advice, and if you have a specific situation or question, please do seek tailored legal advice. And last but not least, please do subscribe on Apple Podcasts, Spotify, or Google Podcasts to our show. So I'm joined today by Ciara Longaigh, who is an associate on the employment team here at Maples. And so we wanted to talk to you today about retirement ages, contractual or mandatory retirement ages. So time and time again, we see that clients are seeking advice on how to accommodate older workers continuing to work after the contractual retirement age that they have in place. And I suppose this is a function of many employers recognizing the very valuable experience which longer serving and older workers can possess. They often will have a very strong sense of loyalty to the brand or to the business. They're well networked. They have substantial banks of social capital. Quite simply, it makes business sense to hold on to all of that value and that institutional memory, even in fast-changing and innovative businesses. So from the worker's perspective, continuing to deploy their skills and their intellect and continuing to be part of a team and making a valuable contribution and remaining financially secure is, of course, a very, very appealing prospect. Now, it's not always a positive story. And as lifespans continue to increase, there are obviously increasing concerns amongst workers about the cost of living, and the idea of retiring at 60 or 65 may actually seem quite far-fetched. So whatever way you look at this, it is most definitely a topic that we are seeing increasingly frequently in practice. It's on our desks, and it is a matter of some concern to employers and to workers alike. So in today's episode, we're going to look at managing retirement, facilitating working post the contractual retirement age, as well as discussing the position in relation to mandatory retirement ages from a legal perspective in Ireland. So, as always, let's start with the basics. So, Ciara, do you want to just give us an overview of really where the law currently stands regarding retirement ages in Ireland?
Sure, no problem. So, as it stands, there is no mandatory or even customary age at which an employee must retire in the private sector in Ireland. In practice, we see a wide range of contractual retirement ages, and that would range typically from 60 to 65. It is unusual to see a retirement age below 60, and perhaps slightly less unusual to see a retirement age of over 65, with some employers selecting 66 to 68 as a mandatory retirement age. However, it's important to note that the state pension age is 66, and even though that is not linked legally to an employer's selection of a mandatory retirement age, in practice they are often closely linked. Currently, age 66 is the age beyond which a state pension will be paid to employees who have made sufficient PRSI contributions during their working life. However, there have been significant developments in this area in recent months. As of January 2024, employees are now able to choose to delay the payment of their state pension up to age 70, should they wish to remain in employment. This will allow employees the opportunity to make further PRSI contributions to meet the requirements to qualify for the state pension, and will also allow the employee to benefit from a higher state pension when they do retire. This is an attractive prospect for employees, obviously, who do not yet wish to retire.
Perfect. Okay, so in essence, retirement ages, if you like, in the private sector are simply agreed between the parties to the contract. They're contractual retirement ages, which are sometimes referred to as mandatory retirement ages, and the terms have become a little bit interchangeable. But if we drill into this a little bit more, is it really accurate to speak anymore about mandatory retirement ages in the private sector?
Well, it's an interesting question, and certainly one which is going to come up more and more often over the next few years. Under Irish law, it is only possible to rely on a mandatory retirement age, or more correctly, a contractual retirement age, in a contract of employment where such retirement age is capable of objective justification. And we'll explore what this means in practice a little bit later on. There's been a lot of recent discussion about mandatory retirement ages and their continued viability. So in March 2024, the Department of Enterprise, Trade and Employment received government approval to begin drafting the Employment Restriction of Certain Mandatory Retirement Ages Bill 2024, which aims to amend the Employment Equality Acts. Under the terms of this draft bill, employers are prevented from imposing contractual mandatory retirement ages lower than state pension age, which, as we said, is currently 66. However, it is proposed that there will be certain exemptions, particularly in relation to retirement ages which are set out in law, which apply to certain roles in the public sector, or in relation to contractual retirement ages for physically demanding or public safety critical professions, where the employer can provide objective justification for a retirement age which falls below that state pension age. It is proposed that this legislation would apply to existing and new contracts of employment, and employees will have the right to redress if their employer imposes a mandatory retirement age which is lower than the state pension age without their consent. It's anticipated that the bill will commence its passage through the Houses of the Oireachtas during the upcoming autumn session, with an appropriate lead-in time to ensure no one is taken by surprise. It will be very interesting to follow this bill's progress through the Dáil and to see if it becomes law, and we will issue a further update if and when this bill becomes law. For certain roles, such as members of An Garda Síochána and the fire service, a mandatory retirement age is enshrined in law. This age is 60 for Gardaí, but is due to increase to 62. And it is worth noting that the mandatory retirement age for the fire service is also due to increase to 62 in the coming months. So again, we are seeing a general movement towards increased retirement ages and facilitating employees staying in the workforce for longer.
Yes, thanks. That's very helpful. And in fact, a lot of the case law sort of derives from those professions and trades and sectors where there are actually mandatory retirement ages in their purest sense, if you like. So let's actually drill into that concept of objective justification that you mentioned. So really, objective justification is a key concept for an employer when they are evaluating whether their contractual retirement age, which many employers will regard as mandatory, but really it is a contractual retirement age. So when they're evaluating whether they can in fact rely on that retirement age, they need to look at the concept of objective justification. So is the retirement age that particular business, that particular employer has chosen, is it capable of objective justification? And really what that means is, in the particular circumstances of this individual who is approaching retirement, is the use of that retirement age, is it justifiable? Is it proportionate? Does it meet a legitimate objective? And if it doesn't, then the position is that retirement age is not enforceable against an employee who is unwilling to retire. So that really tends to be where the case law focuses, and that tends to be where we see the disputes in relation to employers seeking to rely on mandatory retirement ages and employees pushing back and saying, well, I don't want to retire. Now, there is a statutory code of practice on longer working, which we will come back to a little later in the podcast, and we'll also include in the show notes. But it gives us some guidance, if you like, in terms of what does objective justification mean? What are the reasons that an employer can rely on to say we need to have this mandatory retirement age of 60 or 65 or whatever it is. And those reasons, or those objective justifications, include the following. A very common one that is used is referred to as intergenerational fairness. And what that really means is almost like creating opportunities for younger workers to progress by opening up capacity in the more senior ranks of an organization. Another objective justification that is sort of acknowledged and recognized is the need to motivate the workforce and to have dynamism in the workforce through the increased prospect of promotion. Some of the others that I'll just touch on and which are set out in more detail in the Code of Practice are health and safety, and that generally tends to apply in occupations where there's actually a need perhaps for physical dexterity or, fitness to carry heavy loads or to perform certain functions that require good physical health. Another objective justification is creation of a balanced age structure in the workforce. The protection of personal and professional dignity is another one that is commonly used. And then succession planning is also commonly referred to. So in any event, we actually have had a recent Supreme Court decision which looked in some detail at objective justification, not all of the pieces that I've just mentioned, but it certainly looked at some of them. And that is the Supreme Court decision in Mallon. Ciara, you might have the full name of the case. We'll have it in the show notes, but can you talk us through the Mallon case, please?
Yes, absolutely. It was an interesting decision from May earlier this year, in which the Supreme Court rejected an appeal by a revenue sheriff in relation to the 2022 High Court ruling, whereby a mandatory retirement age of 70 was found to be justified and effective in achieving intergenerational fairness. The High Court had found that the use of a mandatory retirement age of 70 avoided difficulties within the workforce occasioned by health and capacity issues. So the revenue sheriff in this case argued that the rule was simply not compatible with the EU directives on equal treatment in employment. He also alleged that no objective or reasonable justification for the mandatory retirement age had been provided. He argued that no assessment of his physical fitness had taken place, and he argued that the working lives in general had lengthened since the retirement age had been introduced. And he noted that sheriffs do not receive a state pension on retirement and had incurred significant losses from the pandemic.
Yeah, so all compelling arguments on the part of the employee, to be honest. And I note in this case that the employer had used intergenerational fairness as one of its objective justifications. In addition, it referred to what I think we could say were sort of presumed health, dignity and capacity issues. So did he succeed? Did the employee succeed in this?
No, he didn't succeed in this case. And in fact, his arguments, although compelling in his personal situation, were rejected by the Supreme Court. So Mr. Justice Collins found that a retirement age of 70 across the public sector and state agencies is not disproportionate and meets a legitimate objective. While the revenue sheriff complained that his physical fitness had not been taken into consideration, the Supreme Court noted that an individual capacity assessment should be avoided by employers because of the scope for disputes such assessments necessarily involve, and also because of its potential impact on the dignity of an employee. The Supreme Court noted that the CJEU case law has recognised that it is reasonable for member states to adopt generally applicable mandatory retirement rules without the requirement for individual capacity assessments. The Supreme Court also examined whether any financial hardship would arise from the mandatory retirement age in this case, and decided that it would not, due to the revenue sheriff's being able to continue in his role as a solicitor in this case. In arriving at the decision, the Supreme Court stated that the member states enjoy broad discretion in this area, and it is for the competent authorities to find the right balance between the interests involved. However, it is clear that this is a live issue in relation to whether mandatory retirement ages are justifiable, proportionate and meet legitimate objectives, as we said. Notably, the decision in Mallon concerned a mandatory retirement age of 70, which was, as it was pointed out, was significantly higher than the pensionable age for the purposes of the state pension.
Yes, indeed. That was an interesting consideration. Now, the intergenerational fairness argument, if you like, has also been the subject of a lot of other case law before the Workplace Relations Commission, and in fact we've a couple of cases to look at. So do you, and in the case that you're just about to talk about, which is Roper versus RTE, in that case the reliance on intergenerational fairness did not succeed. So by contrast, the Mallon decision. Do you want to just talk us through the Roper case?
Yes, indeed, an interesting decision. And as you say, in this case, the WRC determined that in the particular circumstances, intergenerational fairness was not an objective justification for a mandatory retirement age of 65. The adjudication officer in this case observed that to succeed here, it was necessary for an employer to prove that the implementation of compulsory retirement age contributed to intergenerational fairness. The WRC decided that the employer had not succeeded in proving this and that the employee's retirement fell short of achieving intergenerational fairness, as the effect of her retirement was so limited and it was confined to one department. The WRC held, therefore, that as a method of achieving intergenerational fairness, the employee's departure fell considerably short of what would be necessary. As such, the WRC awarded the employee compensation of €100,000 for discrimination on the grounds of age, which was the equivalent of 1 year's salary for this employee.
Yes, and I remember when that case was reported at the time, I think it was back in 2019, that was a very, very significant award. Now, the WRC also has the power to reinstate the employee where they succeed. And actually, quite separately, the whole concept of reinstatement has been the subject of another Supreme Court decision. And it is very much an exceptional remedy. That's a story for another day. But reinstatement did actually happen in a retirement case relatively recently, and I think that is the case of Doolin and Air Business. So would you mind just talking us through that?
Yes, no problem. In that particular case, the employer was ordered to reinstate the employee, as you say, and the employee had been required to retire at 65 against his wishes. The employee had formally requested that he be permitted to continue working past the mandatory retirement age, but this had been refused by the employer due to concerns regarding health and safety, equity and fairness for younger employees. The WRC carried out an incredibly detailed factual analysis in this case. The employer had relied on intergenerational fairness, the necessity for effective succession planning, and the importance of maintaining age balance in the workforce to uphold the individual dignity of an employee, especially in a safety critical role as set out in the company's retirement policy. Upon a forensic review of each objective reason, the WRC found that the employee in question was in fact a junior member of the team. He had quite junior level responsibilities. His continued service was unlikely to hinder the career progression of his younger colleagues. And additionally, he worked an entirely desk-based job, meaning that in reality, there were very few health and safety concerns in relation to his continued employment. Although it is important to note that, in line with the more recent Supreme Court decision of Mallon, which we just discussed, an employer is not required to engage in an individual assessment of the employee's physical fitness to continue on in their role. The mandatory retirement age in this case could not be objectively justified, and there was no issues with the employee's performance, and it was agreed by the parties that his removal from his position was based solely on the company's retirement policies. The WRC also took into account the employee's income, that it would drop by 60% if he was terminated on reliance on the contractual retirement age.
Okay, that's very helpful. Thanks, Ciara. And as mentioned, we will have the Mallon, Roper and Doolin decisions in the show notes. It's very helpful to take a look at those. The courts and the WRC tend to go into quite granular detail in looking at the specific factual circumstances. So it's really helpful guidance for employers in terms of understanding how this is approached. So let's even pause for a moment and maybe pull together 2 or 3 takeaway points from what we've already discussed. I think the first thing is when an employer is faced with an approaching retirement situation, the first thing is to make sure that you go beyond what is written in the contract. So don't simply rely on the fact that there is a retirement age of, say, 65 in a contract of employment. We need to go a little bit beyond that. Second thing that an employer will need to do is consider the objective justification. So what is the objective justification in that business for that retirement age and for that employee? And I would say the third piece is to look at it in a bespoke manner. Is this going to work? Is this a compelling objective justification for the particular retirement situation that the employer is now faced with? And probably a fourth point is, which brings me to our next topic, is to take a look at the statutory code of practice. on longer working. Now, we mentioned the code of practice earlier. It is a statutory code of practice. It's not strictly speaking fully legally binding, but it is a code of practice that the Workplace Relations Commission will have regard to when considering how an employer has addressed a retirement situation. I think I probably haven't got the full title of it there. This is just a working title, but it will be in the show notes. I've talked a little bit about how the Code of Practice explains very helpfully the concept of objective justification, but there are a few other helpful pieces. Ciara, do you want to just talk through some of the other highlights of that Code of Practice?
Yes, a few other points to note. The Code of Practice also highlights that it's good practice for an employer to remind an employee of the contractual retirement age within 6 to 12 months in advance of that date in order to allow for reasonable time for planning and arranging advice regarding succession, etc. While this initial notification should be in writing, it should be followed up with an in-person meeting, which should focus on addressing a number of points, such as ensuring a clear understanding of the retirement age and any possible issues which may subsequently arise, exploration of measures which would support the pathway to retirement, transitional arrangements in regard to a particular post, and assistance around guidance and information coming up to retirement.
Perfect. Okay. And as you said, very strongly encourage listeners who have an interest in this area to take a look at the Code of Practice. Okay. Another piece which we see quite frequently in practice, obviously, are situations where there is no dispute between the parties and the parties agree to a working arrangement that will continue after the retirement age has been passed. So maybe let's look at that just for a moment. Ciara, do you want to talk us through how an employer should approach a request by an employee who has reached the contractual retirement age and who wants to work past that retirement age, and the employer is broadly in agreement? So what needs to be done?
Well, as you say, we are definitely seeing these requests come up more and more, and such requests need to be very carefully considered by the employer. It's recommended that employers consider the Code of Practice, as we've mentioned, when assessing any requests from employees to ensure they're following best practice when they deal with the request. And it's also important, as you mentioned already, that any decision to decline a request for longer working should only be made after an assessment of the objective justification that the employer is relying on to enforce the retirement age. Where any such requests are in fact granted, it's quite common in practice for employees to be engaged on a fixed term contract with a specified termination date. And it's good practice to acknowledge that the decision to grant this particular fixed term contract post-retirement age is made solely having regard to the case being made by the employee and does not apply universally, so as not to undermine the contractual retirement age.
Yeah, absolutely. I mean, although we've spoken a good deal about how, the contractual retirement age cannot be taken at face value, it is still a term of the contract. For the moment, it is a permitted term of the contract, albeit with the requirement to have an objective justification. We also do see situations where there is no written contractual retirement age and employers try to rely on a custom and practice, and that's a tricky situation. In any event, we're not that doesn't come within the ambit of this podcast, and I think we'd need some time to go into all of that and implied terms and conditions of employment. So we're not going to deal with that today. But just one other piece that I wanted to talk about in relation to agreed arrangements where an employee does continue to work post the contractual retirement age, and that relates to benefits. So this is more sort of an operational or practical consideration, but it's very important that when an employer is offering that fixed term contract or that new contractual arrangement, it's important to make sure that all of the benefits which the employer has contractually promised or will promise under the new contract are in fact available to the employee if that employee has reached an age which is perhaps beyond the stipulated eligibility age for those benefits. And that can arise in particular with insured benefits. So the ability to participate in, for example, private health insurance or life assurance. So it's very, very important for the employer to take a look at that, talk to the broker, and just make sure that the benefits that the employee had enjoyed pre-reaching the retirement age that they can still enjoy those benefits where they are engaged to work on after the retirement age. So if they can't for whatever reason, then that will need to be highlighted to the employee. Okay, so look, we've spoken a lot about the use of contractual retirement ages, their limitations, how to approach a situation where an employee is retiring or requesting to work beyond that, and some of the practical considerations. Maybe let's just frame this, bring it back down to a slightly more legalistic discussion. Do you want to tell us, Ciara, why does this matter? What happens if it goes wrong? What is the legal risk associated with this?
Well, there is a risk of mandatory retirement policies being held to be discriminatory on the basis of Section 8 of the Employment Equality Acts, which provide that an employer should not discriminate against an employee. So discrimination is deemed to have occurred if an employee is treated less favourably than another has or would be treated, and therefore requiring an employee to resign from their job may be seen as discriminatory because it involves treating an employee less favourably due to their age. Where an employee successfully argues that they have been discriminated against on the basis of age, the WRC can award compensation of up to 2 years remuneration or €40,000, whichever is greater. And as we've already spoken about, the WRC can make an order for reinstatement or re-engagement and can make an order that a specified person takes certain action. It is worth noting, however, that Section 34 of the Employment Equality Acts allows for mandatory retirement ages at present to be imposed if the policy is objectively and reasonably justified by a legitimate aim, and the means of achieving that aim are appropriate, necessary and proportionate.
Thanks, Ciara. Yes, that's absolutely key, bearing in mind those sort of three key concepts: that it's appropriate, that it's necessary and that it's proportionate. Look, it's a developing area. We will be keeping a close eye on it in the coming months. And if there's any update in relation to the case law or the legislation, we will probably hop on again to talk about this topic. So for now, thank you for listening to the Maples Group Employment Law Podcast. If you have any questions or queries on any of the points covered today or on any employment legal issues in general, please do get in touch with us. Thank you very much for listening and subscribing.